everyone. Thanks for joining us in this webinar today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. So today we're going to spend some time discussing the visa options available for individuals with extraordinary abilities in their fields. So just a few housekeeping things before we get started. Scott Legal is a full service immigration law firm, which means we do have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based matter, employment-based matter, or an investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law related topics, which are very informational. So please feel free to follow us for more webinars that are coming up in the future. At the end of this webinar, we will be sending out a few resources to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar today. Second, we will be sending you a comprehensive visa guide, an ebook that contains information that could be helpful to you in navigating those visa categories we will be speaking about today. We will also send you a link you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button for our YouTube channel, as we do regularly upload a variety of immigration law related videos. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced lawyers, should you wish to discuss in more detail the particulars of your case. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. All right, so without further delay, let's get started. So the first topic to go over is pretty much an overview of what are the extraordinary ability visa categories. So let's start with the O-1A and O-1B visa. So the O-1A and O-1B visa are temporary visas. That means this is not a green card. It is well suited for individuals who have work arrangements in the United States, who seek to be in the United States for a temporary period of time. You can continue to extend the O-1 visas as long as there is continuing work in your field of extraordinary ability in the United States. But as a principal matter, those are temporary visas. So let's look at the O-1A visa. So the O-1A visa is a non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. And the standard to qualify for an O-1A visa is that the person must have had national or international acclaim, which means he or she must be well known, and must be one of the small percentage who has risen to the very top of the field. And that is quite a lofty language of a standard to meet. So there is a variety of types of evidence you can collect to support the case that you have reached that level. And really the key word to think about is recognition. How can you show that you have received recognition in your field that is widespread and at a national level? For example, being featured in major media, for example, or having received national level awards. Those types of evidences can definitely help to meet this lofty criteria, and it can be actually more accessible than what a lot of people may think. All right, so let's then talk about the O-1B visa. So the O-1B visa is intended for individuals in the arts, the motion picture or television industry. So motion picture here means film. So there are a couple of different standards depending on what category is your field. So if you're in the arts, so pretty much fine arts or other types of creative arts, such as graphic design, for example, that can be one example. The standard to meet here is distinction. And distinction is defined as that you are operating at a level that is substantially above that is ordinarily encountered, such that you can be described as someone who is prominent, leading, or well-known in your industry. So keep in mind that this language is slightly different from the language that I just described for the O-1A standard. So for the O-1A, they're looking for someone who has risen to, national or international acclaim, and you're one of the small percentage who have reached the very, very top of your field. But the standard that's required for the O1B is slightly lower. As you see, the keyword is distinction. So as long as you can show that you are substantially above what is ordinarily encountered in the field in terms of being well known, you could have a good chance for the O1B. Similarly, for the motion picture and television industry, what they're looking for is a level of acclaim that is substantially above their peers. So as long as you can show that relative acclaim that you have achieved in your field, you may be able to qualify for the O1B visa. All right, so now let's talk about the EB-1A green card. So as I've mentioned before, the O1A and O1B are both temporary visa options. You are given a temporary period of time for you to live and work in the United States. By contrast, the EB-1A is a green card category. It gives permanent residency in the United States. So let's talk about the standard for the EB-1A green card. So in order to qualify for the green card, for all fields, you need to meet one standard, and that standard is to show that you have received national or international acclaim and are one of the small percentage who have risen to the very, very top of their field. And you can see that this language mirrors the one that I just discussed for the O1A. However, in practice, when USCIS officers are judging EB-1A petitions, they look at this with a very, very strict eye. So with the same package of evidence that let's say you were approved for the O1A with that particular evidence package, when you're using that exact same package for the EB-1A, every single evidence that you submit will be looked at with a much stricter eye in the EB-1A context. And that is practically because, a green card is more valuable, and it also directly leads to eligibility for U.S. citizenship. So the USCIS officers are looking at these petitions with a very, very stringent eye. And I will talk a little bit later about the Kazarian test, which gives even more scrutiny to those types of petitions. And interesting to note is that the EB-1A green card is for all fields. So although the O1A and O1B visas are separated for each types of fields, so the O1A for people in the sciences, education, athletics, and the O1B for arts, motion picture, television, but for the EB-1A, there is one standard that applies for all fields. So even if you were approved for the O1B visa under a distinction standard, for example, you do need to kind of up your portfolio to try and meet the higher standard that's required for the EB-1A. For all three categories that I just mentioned here, there must be some evidence that you are coming into the United States to continue working in your area of extraordinary ability. So in the case of the O1A and O1B, there must be some evidence of what is the work arrangement that you're coming to the United States for. For the O1A and O1B, for example, there either needs to be a petitioner who is the employer who is planning to employ the beneficiary, or the O1A or O1B visa can be filed by an agent. So an agent will then provide information, an itinerary, a 3-year itinerary describing what the projects are that the person will be completing in the United States, and evidence of contracts showing the existence of this work with a U.S. Employer. Now, for the EB-1A, this category does not require a job offer. It does not require the person to have a U.S. petitioner. So the foreign national himself or herself can be the individual who drives forward the petition for the EB-1A. However, the self-petitioner is expected to write a statement of intent of what they're planning to do in the United States if their visa petition is approved. And it must show an intent to continue working in the area of extraordinary ability. So let's say if you are an extraordinary scientist, you can't you can't just come to the United States to just apply for a green card and retire right after. You do need to show your intent to continue working. That is the basis of granting the green card. Now, another category that we will mention after we discuss the O-1A, O-1B, and the EB-1A is the EB-2 NIW green card option. And you may have heard of this category. It's kind of a category that is growing in popularity, which also um, allows someone to self-petition for a green card without having a US job offer, without having sponsorship by a US company. So it can be a very attractive option in some people with certain types of degrees of work that um, that is amenable to the argument that your work is of national importance to the United States. So that is the key here, right? So if you are one of the people who has extraordinary ability, there can be kind of an overlap with the NIW potentially. Let's say if you are a leading scientist in, discovering treatments for diseases, for example. Maybe you can make an argument that you would be performing research in your field that can improve best practices in treating such diseases, and that can help, critical public health issues that the US is facing. And you can use that kind of argument to support a potential national interest waiver petition and qualify for the NIW that way. So there can be quite a bit of synergy between the EB-1A, the O-1, and the EB-2 NIW, which is why we added this to the list of visas to discuss. All right, so then let's now move forward to discuss in a little bit more detail about the specific types of visas and what you need to show that you are eligible for such categories. So to begin with the O-1A, and as I mentioned before, the O-1A visa is for people in the fields of sciences, education, business, or athletics. So there are two ways to prove that you qualify for the O-1A visa. And the first way is to show that you have received a major one-time international level award, such as, a Nobel Prize or, however, to do that, the prize itself must be very, very famous. So in reality, 99% of the cases that we deal with is the second category, which is people who need to show at least 3 out of the following types of evidence. And just because it is just so rare to find someone who has, been awarded the Nobel Prize or that kind of major international award. So let's look a little bit closely at the other enumerated criteria. So receipt of nationally or internationally recognized prizes or awards. Here, they're talking about lesser awards than the Nobel Prize, for example, but they are still looking for national level prizes. So if it's more of a university level prize, for example, a student award or a student scholarship, that may not be enough to meet the evidentiary criteria that they're looking for here because it may not be considered a national level award. However, by contrast, let's say certain types of scholastic awards for, a leading national conference, for example, if you were awarded the best paper or best presentation at that leading international conference, depending on the nature of the conference, you may be able to use that kind of award. So really what you want to look at is what is the admission criteria for that award and what is the selection criteria for that award? And can you show that getting this award is, somehow nationally recognized? That is one of the criteria to keep in mind of. Membership in associations in your field, which require outstanding achievements. So what is important here is to look at all of the languages that is included in the criteria. So not only are they looking for associations in your field, they're also looking for whether they require outstanding achievements to be able to join that association. So this is a common misconception that all types of professional associations can work for that purpose. For example, I'm a lawyer. I am a member of, the American Immigration Lawyers Association. However, you don't need to go through, a panel of experts, for example, to show that you have already made a significant contribution in the field of immigration law in order to, join that association. So in that case, I will not use my membership, for meeting the O-1A criteria. However, let's say you're an engineer, and if you, were elected for the fellow grade of the IEEE, which is a professional association for engineers, and to be elected a fellow grade, you do need to go through a very rigorous selection process and be nominated and go through, evaluation through, an expert panel and things like that. So if you can show all of these selection criteria, there is a good chance you can prove that your selection to the fellow grade of the IEE shows, membership in association in your field that require outstanding achievements. And there are other similar criteria here of evidences. 3 out of this you must meet to pass to the threshold. But what I want to say here is both the volume of evidence and the quality of evidence is important when you're trying to build a case for the O-1A. And I do advise clients to try and meet as many of these criteria as possible because optics is very important for, when you're building the package of evidence because as a general matter, as a holistic matter, USCIS is looking for a volume of evidence that shows that someone has indeed received that level of national or international acclaim that shows that they are one of the top, players in the field, supported by extensive documentation. Let's see. One criteria that I think is underused, but I think that could be very relevant, especially for people who are working in startups or working in R&D for innovative startups, is this last prong: employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. Now, distinguished reputation can be shown in a variety of ways, right? So let's say you're one of the founding members of a startup that has been, received numerous media attention for its innovations, for example, and let's say the startup was able to raise millions of dollars in venture capital funding. All of these types of evidences can show that this startup is an organization of distinguished reputation. And let's say you are one of the founders. There is a good chance you may be able to prove that you have worked for that organization in a critical or essential capacity. So when I work with entrepreneurs, for example, this is one criteria that I like to use to really showcase the individual's accomplishments that have impacted the field. All right, so then let's move on and talk a little bit about the O-1V visa. As I mentioned before, the O-1B visa is intended for individuals in the arts, motion picture, which is the film industry, the television industry. So similar to what we just discussed in the O-1A, there are 2 ways to describe the beneficiary's qualifications. The first way is to show a major international level top award, such as an Emmy or a Grammy, kind of like the Nobel Prize. Or in the vast majority of cases, you will need to show at least 3 out of the following minor criteria that is listed here below. And the types of these evidences is kind of similar to the ones that are relevant to the O-1A. You can take a look here: performing in a lead or starring role in productions or events that has a distinguished reputation, kind of like the critical role that we just discussed earlier. Published material about the person, showing that this person has achieved national or international recognition for the work that they're doing. Major commercial or critically acclaimed successes in the performing arts, for example. Evidence of significant recognition and expert opinion letters can really show a big role in, supporting this criterion. In particular, evidence of having commanded a high salary, and other comparable evidence. If you can show that a particular criteria is not immediately applicable to your industry, you can try to meet this with comparable evidence. So as the holistic picture that the evidence package must show is that you have reached distinction, right? That you are operating at a level that is significantly above your peers, significantly above what is ordinarily encountered in the industry. So you can see that the threshold that they require for the O1B is slightly lower than what is required for the O1A, which requires that you have reached the very, very top of the field, one of the small percentage that has reached the very top. All right, so then now let's compare the O1A and the O1B and talk about the similarities and differences for such criterias. So what fields are applicable? So for the O1A visa, it is limited to people who are in the sciences, education, business, or athletics. The O1B visa is meant for people in the arts, motion picture, or television industry. The standard is different. So for the O1A visa, as I mentioned before, you have to show through evidence that you are one of the small percentage who has risen to the very top of your field of endeavor. For the arts, you only need to show a high level of achievement as evidenced by a degree or skill and recognition substantially above what is ordinarily encountered in the field. And for the motion picture and television industry, you need to show that you have reached a level of acclaim significantly above your peers. Now, I do want to mention that in some cases, in some fields, you may be able to choose whether you go for the O1A or O1B. For example, let's say you were a renowned tattoo artist, right? Maybe you can be classified as a business person and go under the O1A standard, or you can maybe be classified as an artist if you can show that, tattoo design is an art. So if you choose the O1B, right, maybe strategically it makes sense because then you would face a lower hurdle to show a high level of achievement of distinction relative to your peers rather than having to show that you are one of the small percentage of tattoo business people who have reached the very top of that field. So strategically, sometimes there could be some wiggle room to go either O1A or O1B. The length of the visa. So both for the O1A and the O1B, the length of the visa issued is the same. So for the initial O1 approval, you can get up to 3 years. And for extensions, if you are continuing the same body of projects that you have been approved for the initial visa, then it's a 1-year extension. But if you have a new body of projects that you will be completing in the future, then you could get a 3-year extension too. So potentially you can continue extending for 3 years and 3 years as long as there is a corresponding list of projects in your itinerary and you can provide support for that. And there is really no lifetime limit on how long you can be on the O1 visa. And I have practically seen many clients extend it over and over again. And the O1 is actually one of the visa categories that lawyers say it is quasi-dual intent, which means the O1 is a category that is quite more lenient to the question of immigrant intent. So there are a couple of other visa categories that people may get a little bit more difficulty when they try to extend too many times. For example, the TN visa is one example. When you try to extend too many times, then you run into the question of, wait, aren't you trying to immigrate to the United States permanently? Right? But for the O1, you don't need to worry about that as much because it is a quasi dual intent visa. I mean, definitely speak to your lawyer if you're juggling potential immigrant plans. There can be some strategies there. But as a general matter, there is no lifetime limit to how long you can be on the O1 status when you're in the United States. Can family come to the United States? The answer is yes. Your spouse and your minor children can come to the United States with you on an O3 dependent visa. And your spouse and or children can attend school when they are on the O3 visa, but unfortunately, there is no work authorization that is given with the O3. So if you bring your spouse, unfortunately, they cannot work while they're in the United States on O3 status. All right, so then let's go on and talk about the EB-1A green card option. So as I mentioned in the first slide, the EB-1A is the green card category for individuals of extraordinary ability, and it is a category where someone can self-petition for a green card, as opposed to requiring a US employer to sponsor them or requiring a job offer. None of that is required, so you can be, the foreign national can be the one who is driving forward the petition. So one thing to note is that the standard of extraordinary ability to qualify for this EB-1A green card is very high. And part of this is because USCIS engages in what is called a Kazarian analysis, a two-step analysis, which not only looks at whether you can submit at least 3 out of the 10 criteria that's mentioned here, but also they look at the quality of the evidence and ask whether holistically as a whole, the whole package of evidence, the volume and quality, does it paint a picture that the person has indeed reached the level and is one of the very small percentage of people who have risen to the very top of their field of expertise. And as you know, reaching the very top can, it is a little bit of a subjective standard, right? And you can understand the O-1 as that USCIS will be a little bit more lenient and when they're thinking about what is the very top. When you're being judged for the O-1A, they'll be like, oh, okay, this is top. But when your application is being judged in the EB-1A standard, they will look at it with a very, very strict eye. So there is that kind of subjectivity room there. Even when you're looking at the same evidence package, you may have a more difficult time with the EB-1A, and it may be a good strategy to strengthen your profile with the help of a lawyer. Really consider bolstering your portfolio with stronger forms of evidence if you're looking to apply for an EB-1A in the future. So the first step of the Kazarian analysis is whether you have technically submitted evidence that is meeting at least 3 of the 10 criteria. So as we mentioned before, either you qualify by showing that you've received a major internationally renowned award like the Nobel Prize, for example, or in the vast majority of cases, you will prove that you've submitted 3 out of 10 minor criteria evidence categories, which mirrors the language that we discussed in the O-1A context, including, for example, being featured in major media, having received lesser national level awards, being a judge of the work of others, having played a leading or critical role in distinguished organizations, being admitted to membership in associations that require extraordinary ability or things like that. So in step 1, technically, if you show any evidence meeting the criteria, the plain language of the criteria, you will pass step 1, right? So let's say you've published 1 academic paper in a journal. Let's say you've conducted 1 peer review, and then your work was discussed in 1 article in an industry newspaper. You can submit that, and that'll be enough to pass step 1. But you will definitely then receive a more challenging time in step 2, right? Because it is not just enough to pass step 1 of the Kazarian analysis. The step 2 analysis is a more holistic assessment of your profile as a whole. So USCIS will look through the totality of the evidence to see if the volume and quality of the evidence really paints you as someone who has reached the very, very top of the field. So let's take media, for example. Like, let's say you were featured in a small industry newsletter for your professional field that has 1 paragraph discussing you and your work, and compare that with the scenario where you were featured as a cover story on a major magazine like Time, with a photo of you on the front page, including a 3-page full feature article talking about you and your work, and that's the major focus of the article. Clearly, the latter case presents a stronger case in the step 2 analysis of the Kazarian framework, right? So, and that is more consistent with the definition of an EB-1A candidate that USCIS expects to see under the Kazarian analysis. So that is why I say both the quantity of the evidence and quality of the evidence is important, and you want to look at the individual pieces of evidence and really assess how strong they are when you're building your EB-1A case. All right, so then now let's shift gears a little bit and talk about the national interest waiver, the EB-2 NIW, which is another popular green card category, and that can have some overlap with the extraordinary ability candidates because, if you have, achieved a certain level of acclaim in your field, you may be well positioned to talk about your influence to the field, and if you can connect that with areas of national importance to the United States, there can be some potential NIW arguments there. So to qualify for the EB-2 NIW, the first eligibility criteria to meet is, do you have an advanced degree? So the EB-2 threshold criteria can be met by either showing that you have an advanced degree or by showing that you have exceptional ability in the sciences, arts, or business. Now, what is an advanced degree? So an advanced degree is defined as a master's degree or higher. So if you have a PhD, you obviously qualify. If you have an MBA, that will qualify. If you have a JD or an MD, for example, that also qualifies as an advanced degree because you typically need to have a bachelor's in order to qualify for admission to that kind of program. Now, if you don't have a master's degree, if you don't have a PhD degree, you can also qualify as an equivalent of a master's degree holder if you can show that you have a bachelor's degree plus 5 or more years of full-time progressive work experience in your field following the time you received your bachelor's. So what does progressive work experience mean here? So progressive work experience means that your job duties and your responsibilities didn't just stay the same within the 5 years, but they accumulated, and that you can show an upward trajectory in um, the seniority of the duties, the complexity of the duties that you were asked to perform. So when you are planning to show that you have, the bachelor's degree and the 5 years of experience, it is very important to get an employment confirmation letter from your previous employer that not only proves that you have, worked at least 5 years full time, but also provide enough detail about the duties that you performed and provide enough detail about how those duties changed. And sometimes your salary could have changed upwards. Sometimes your title could have changed from, for example, associate to, senior associate to partner, for example. And those kinds of details are really important to substantiate that you have accumulated that progressive work experience. So you will need to show that if you're meeting the threshold in that way. Now, the alternative way to meet the EB-2 threshold is by showing that you have exceptional ability in the sciences, arts, or business. And this is relatively an easier standard to meet compared to the EB-1A standard, which requires extraordinary ability. So to show exceptional ability, you need to show that you can provide at least 3 out of the 7 criteria of evidence. And the evidence is slightly different from what is required in the EB-1A context. For example, any degree related to your field, that's one criteria. 10 years of full-time experience in your occupation, that's another criteria. That you have a license, that's another very straightforward criteria you can meet. High salary, that's the same one with the EB-1A. Membership in any professional association. So you don't need to show that you are a member of an association that requires extraordinary ability, but in the context of exceptional ability, you can just show that you're a member of any professional association. Evidence of recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations. That one, you can definitely harness expert letters to show that recognition, and combine it with objective evidence that will strengthen the case. So for example, if you have made original publications in your field, published in journals, if you have developed new technology that has been patented, you can also include evidence of those work product as objective corroborating evidence and combine that with expert letters explaining why this is a significant contribution to your field. Evidence like awards, for example, and recognition certificates from government agencies, from professional agencies, those types of evidence can also be helpful for meeting the EB2 threshold. Now, meeting the EB2 threshold, however, is not the end-all be-all of an NIW application, because one very challenging part of the NIW is that you do need to meet what is called the three-prong matter of Danaher criteria to prove basically that you qualify for the national interest waiver. And the NIW really is kind of a privilege that you get because ordinarily for employment-based immigrant petitions in the EB2 category, you do need a job offer. You do need a US company to sponsor your petition and go through what is called the labor certification requirement, which means that the US employer is required to test the labor market to see if there is a US professional who can fill your place. Does the US professional have the minimum credentials to do the job? And if the answer is yes, the whole process must stop and the job must be given to a US applicant, and it can't be used to support the green card. So it is obviously a very onerous process and a very time-consuming process that can really push back your timeline for a green card to the far future. And you do need to also get a US employer to be able to work with you through these many years. And for certain people, that certainly is not practically an option. So if you qualify for the NIW, by contrast, you're exempt from that onerous requirement, which means if you can show that your work has the potential to significantly advance matters of national importance, right? So if your work has the potential to advance best practices in your field and have that broad impact that really outweighs the ordinary benefits of saving one job for one US worker, then you can try to prove the case for an NIW. And if you're approved for that, then your green card petition will be approved, even if you don't have a US job offer and even if you don't go through the US labor certification requirement. So then how do you prove that you're qualified for the NIW? So the first criteria is that the foreign national must be able to prove that their proposed endeavor in the United States has both substantial merit and national importance. Um, so so substantial merit and national importance, what does that mean, right? So substantial merit can be proven in a wide variety of fields, including business, including health, education, science, or technology, and endeavors that tend to further human knowledge in those key areas, such as medical advances, civil engineering, improvements in engineering processes, improvements in manufacturing processes. Those types of endeavors are well suited to, be found to have substantial merit and national importance. Now, in this inquiry, a strong economic impact could also be helpful in supporting claims of national importance. So if your endeavor has the potential to bring substantial positive economic impact, especially to areas that are seen as less developed or targeted employment areas, for example, especially if you are an entrepreneur and if you're bringing in new jobs and new investment into a particular region, you can rely on that kind of argument to show national importance. So really the key question to ask here is, what is the future impact of your work and how is that important to the United States? And how does the benefits outweigh the ordinary benefits of a labor certification in a broad and systemic way, right? So one thing you may want to do when you're preparing an NIW application is also do a little bit of research on, government reports and government, executive orders and federal initiatives, which can really help show why certain areas are a key priority for the US government, such as certain technologies that the US is keen to develop, like AI or 5G networks or infrastructure, for example, or environmental sustainability that has also been a key priority of the administration. So those types of government pronouncements can be helpful in supporting an NIW case for a claim of national importance. The second prong of the matter of Danaher test is that the person must be able to show that they are well positioned to advance the proposed endeavor. And here, the inquiry is on the individual. So if you have no experience at all related to what you're planning to do, then you may be, you may fail the second prong, right? So what the government looks at then is the individual's record of success in similar and related endeavors. A combination of your education, your experience, and your record of previous projects that are related to the proposed endeavor would all be relevant in this inquiry. And finally, the third criteria is, there must be showing that on balance, it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification, which is what I mentioned earlier. How does the balancing test work out? What are the scope of the benefits that your work has to offer to the field as a whole, compared to the ordinary benefits, which is saving jobs, for US citizens and US permanent residents. Now, if you are an entrepreneur and if your business project has the potential to generate a high number of US jobs, then the answer to the third prong would definitely be yes, because, if you can propose a business plan that shows a detailed hiring table talking about what kind of jobs will be created and how, will they be high paid jobs and how much tax revenues would this generate, how much, economic productions would be, generated through your work, then you may have a very good argument that on balance, it will be good to allow you to come to the United States to develop your endeavor, as opposed to, taking the opportunity away to save one job for one US worker. However, keep in mind that you must be able to meet all three matter of Dennis-R criteria in order to qualify for the NIW. So you can't be approved for the NIW with just meeting prong 3. You need to be able to show that you meet both prong 1, prong 2, and prong 3. So that can be a challenge. All right, so now let's turn to an interesting topic here, and that is expert opinion letters. Expert opinion letters are a very important element for all of these extraordinary ability type visa petitions, relevant for both O-1, EB-1A, and NIW petitions. And the purpose is a little different for each category. So for example, for the EB-1A and O-1A, you would want the experts to provide their opinions to confirm that you have extraordinary ability in your field and is well known and have sustained national and international acclaim in your field for your outstanding achievements. Whereas for NIW letters, you may want to focus more on the national importance, the outsized impact your proposed endeavor has to the field. And in the context of NIW, for example, the importance of government agency letters take a heightened role. So for example, if you're someone who's working in agriculture, and if you can get a letter of support from someone involved with the USDA, that can be a very strong push to strengthen your petition. So that is a particular consideration for NIWs. So that is to say that expert letters play a huge role in all of these petitions. Who is writing the letter? So you definitely want to try and get letters from leading experts in the field in your network who typically have decades of experience. And we would typically add the full length curriculum vitae, the resume with, with the expert letter to show the credibility of the expert, which would encourage USCIS to give more weight to that kind of letter. So people who occupy senior positions in leading institutions, for example, for example, for the O1A, EB1A, peer leaders in your industry, and for NIW, as I mentioned before, government agencies are a very favorable type of letter to get. And another important consideration is, how does the individual know you? So there are a couple of considerations here. So the first thing to note here is that nowadays I also encounter clients who say, oh, can I pay someone to write a letter for me? And for those types of things, I always discourage them. I recommend that they don't. And the reason why is because USCIS tends to trust objective letters, and the more of an objective relationship you have with that person, the more credibility USCIS will give to that letter. So for O1, EB1, and NIW petitions, I typically counsel clients to use a mix of independent letters and inner circle letters, which I call. Now, independent letters are people who have not directly worked with you in the past. Like, for example, you weren't part of the same, you know, employer, for example, like more people who are more loosely connected to you. So a friend of a friend, for example, or acquaintance, or someone that you met through conferences, those can be more loosely connected network that you may have that may be able to provide an independent letter. Now, inner circle experts, on the other hand, are people who have worked with you in the past. And those letters can also be important because those letters provide a more detailed account of your previous work. And they can really provide more context about the critical roles you have played in a particular distinguished organization, for example. And they can confirm what impact your work has had before, and also prove that you're well positioned to continue your proposed endeavor if you're using that expert for an NIW letter. So in addition to having a mix of independent and inner circle letters, what is important is to make sure that the expert letters have the right level of content that will really help support your case and really help meet the level of sophistication that USCIS is expecting in those types of petitions. So it is important to note that expert letters that tend to be formulaic, conclusory, or kind of a copy paste of the regulatory requirements, or kind of based on a, a template, for example, those types of letters tend to be not very effective. And USCIS tends to discount them if there is not enough concrete details that is included that really show that the letter has some substance, that the letter is really talking about you as, your unique skills and your unique achievements. So that is why when I say when people come in and say, oh, is there a sample? Is there a template that we can just use for those types of letters? I highly discourage that because the more generalized and conclusory sentences that an expert letter has, the more likely that USCIS is to discount them and just not rely on them at all. So for example, what is really helpful is including specific examples and case studies of your work, right? Because those case studies can support why your work has made an outsized impact in your field and support why your work is distinguished from the vast majority of other professionals who do the same work. And in the context of the NIW, those types of case studies can also provide specific concrete details about the impact that your work has had in improving best practices in the field as a whole. And that can also support that your future work will also have such outsized impact to the industry. All right. So certain strategic considerations when you're trying to choose which category to apply for. So the first question to ask is, what is your intent in, coming to the United States? Do you intend to stay in the United States temporarily or permanently? So as I mentioned in the previous slides, the O-1A and O-1B are both non-immigrant temporary visas. By contrast, the EB-1A and NIW are green card categories. They confer permanent resident status and really are well suited for people who want to live in the United States permanently. And this is important because if you are approved for a green card, for example, there are certain things, there's certain requirements that are asked of you. So, for example, there is a minimum amount of time that you're expected to stay in the United States. When you leave for a prolonged period of time and try to come back, you may get you may encounter challenges. You may also be ending up abandoning your green card if you stay outside of the United States for too long. So depending on your plans and your ties with your home country and your needs to travel for a prolonged period of time, the O-1 may be a better option because there is no such limitation. You can come, as rarely or as, frequently to the United States as you want, as those are temporary visas. However, if you have your eye into, permanent residency and citizenship in the future, the EB-1A and NIW are the way to go. Another question to ask is, do you have a U.S. employer or agent, or do you need to self-petition as a foreign national? So the O-1A and O-1B both require a US-based petitioner, which means you would have a US employer who is giving you a job offer, or a US agent who is, a US citizen, who can coordinate the activities for you in the United States. Now, for entrepreneurs, if you found a new US entity, right, a corporate entity, if you establish a US corporation, that corporation can actually act as a petitioner for your O-1. So it is okay in the O-1 context for you to be the owner of that particular company, and that US company can be considered a separate legal entity from you. So even though if you are even though you can control the O-1 entity, that entity can still drive forward your petition. So that is one option available for entrepreneurs that we have been seeing that could work. Now, the EB-1A and NIW, both green card petitions, do not have that same limitation. So the foreign national himself or herself can be the main driver of the petition. So there is no need for a technical US petitioner. There is no need for a US agent. You do need to prove that your work in the NIW context, you do need to prove that your work will have, some sort of impact to matters of US national importance. So there needs to be some evidence that the US, industry is interested in your work. So in that way, sometimes I recommend clients to get a letter of intent to cooperate with the petitioner once their immigrant visa is approved, for example. But for the EB-1A, for example, you don't even need that. For the EB-1A, a signed statement by the applicant is sufficient, detailing their plans to, come in and work in the United States. So no US job offer is required at all. So that can free up, some options for people. Family considerations. As I mentioned before, if you are on an O-1 visa, your spouse and minor children can come with you as O-3 dependents, but there is no work authorization available for O-3 spouses. By contrast, if you are approved for a green card under either the EB-1A or NIW category, your spouses and children, minor children, can apply for green cards as well as dependent beneficiaries, and also benefit from work authorization, travel authorization, if you choose the I-485 option to adjust status from within the United States. All right, so considerations when moving from a non-immigrant visa to a green card. So that is an important thing to go over because of several things. So the first issue is that different qualifications are required for the O-1A as opposed to the EB-1A. And I have mentioned this at various times in previous slides, but even though the regulatory language is very similar, in practice, USCIS judges EB-1A petitions with a much stricter eye than compared to the O-1A, and especially the O-1B. And the O-1B actually requires a lesser standard of distinction that is definitely different from the standard that's required for the O-1A and EB-1A, which is someone who has reached the very, very top of their field, one of the small percentages of experts. So this is to say that qualifying for an O-1A or O-1B does not mean you automatically qualify for the EB-1A. So in that case, some strategy may be helpful. Speak to a lawyer to really assess the strength of the individual elements in your petition. And if there are any weak points, then it may benefit you to take a couple of years to really collect stronger evidence, responding to each category, such that when you apply within 2 years, within 3 years, you will have a stronger case for the EB-1A, even if your O-1A petition had such weak points. Timing is another strategy factor. So consider how much time is left on your current non-immigrant visa. So if you're on a TN visa or if you're on a different visa, consider the timing of applying for an immigrant petition, such as an EB-1A or an NIW, because some visas may be harder to extend or renew once they have in your record that you have filed an I-140. So the I-140 is the underlying petition for immigrant classification. So if you're, applying for EB-1A or EB-2 NIW, you would file the I-140 first, and then once it's approved, you will be able to file for the green card. But in some visa categories that really focus on non-immigrant intent, if there is a record that you filed the I-140, the consular officer, for example, or the border officer, if, for example, in the context of a TN visa, you may encounter more questioning regarding your actual intent, whether it is truly non-immigrant intent. So definitely speak to your lawyer if you're navigating such risks. It may be a better strategy to wait to file the immigrant petition after you have successfully renewed your visa. Now, family considerations, aging out is a major issue if you have children who may need the green card, and if they're nearing the age of 21, it may be a good reason to expedite your preparation and submission of an I-140. Depending on the priority dates, there could be a delay, so that can also be a factor in, choosing which category to apply with, and a lawyer can certainly help with that kind of strategy. All right, so the last topic I will go over before going to the Q&A is, are extraordinary ability categories available for entrepreneurs? And the answer to this question is yes. EB-1A and NIW, as I mentioned before, both allow for self-petitioning, which is a great advantage for entrepreneurs many of whom may be self-employed and do not have that U.S. job offer connection, U.S. petitioner connection that the O-1 requires. Changes in the NIW standard under the new matter of Danizar case law that came down in 2016 did make NIW a much friendlier category for entrepreneurs. For example, the matter of Danizar specifically talks about significant positive economic impact as one example of an endeavor that has national importance. So entrepreneurs can certainly take advantage of that kind of positive language there. It is possible to apply for an O-1 visa as an entrepreneur if you have a separate legal entity in the United States that can act as the petitioning entity for your O-1. It is quite a complicated fact pattern, though, so definitely work with a lawyer who has direct experience navigating this. We have done many cases where the entrepreneur had ownership in that entity, but there must be other ways to show that there is actual bona fide work available in the United States. So there can be different strategies to navigate that. All right, so now then I will move on to questions and answers. It looks like there are several. Okay, hello, I'm currently in the United States on E2. If I qualify for EB-1A, can I do a change of status here in the United States? And so the answer generally is yes. So if you're in the United States with a valid non-immigrant status, and if you so there are two predicates. So first, your I-140 must be approved, and second, your priority date must be current. So in the EB-2 NIW category, there is a huge backlog, which means even if you have an approved I-140, which is the first step underlying petition, there can be almost a year delay before your priority date is current and you can file for the green card. Which is because there are more applicants for the green card than there are visas available in any given year. EB-1A, I think, depending on which country you're from, could have shorter waiting times. So if the, priority dates are current by the time you need to apply, by the time your status is still valid, then yes, you can file what is called an I-485, which is the adjustment of status petition to change your status to a green card holder. So yes, that is technically a possibility. So will we get the link to the recorded webinar? And yes, you will get the link. We will send this link to all participants once the webinar is done. And for Jordanians, yeah, so I don't have the current visa bulletin in front of me, but what you can do is search for immigrant visa bulletin. And you can scroll down to where it says, employment-based visa petitions, and you can, read the table. We have a very detailed blog post on our website that shows how to do that. So what I'm saying is, if the priority dates are current for that particular category in that month for, a particular nationality, well, actually, the country of chargeability is based on your country of birth, not your current nationality. So technically there is a difference there. But yeah, do the analysis. And if your priority dates are current at that given time, then yes, you can move forward to filing the I-485 once you have the I-140 approved. All right, so it looks like we have answered all the questions. So we will close here. Thank you everyone for your participation. I hope this information was helpful. And if there's anything we can help further, please feel free to reach out for us. We'd be happy to set up a consultation with you. So have a good day, everyone, and see you at the next webinar.